No.
Chair, so that's the ruling on this recommendation.
Chair, and on that reference to the SG for D, question to the SG, isn't it already a requirement in the procurement process that you declare a conflict of interest if you have one, generally across the public service, whether it's a ministry, department, or agency? If you are dealing with a matter in which you have a conflict of interest, isn't the policy and the, I don't know that it rises to the level of, no, actually, it might be in the staff orders as well.
It is in the staff orders,
yes.
Yes, but they have gone further, right, when it says create an offense.
Right.
So yes, if you are a civil servant, you have to declare any conflict of interest, and it's a requirement. It's basically one of our terms and conditions of employment. And if we are found to be in breach, we could be sanctioned by way of a disciplinary process, disciplinary proceedings. But there is no criminal sanction, and the proposal in D is for an offense to be created. But generally, our regime is that we don't have criminal sanctions for those matters, but this is what this request is about.
But we certainly do have disciplinary sanctions.
Right, disciplinary proceedings.
Absolutely,
yes.
Okay. So SG, I'm
sorry, and the disciplinary proceedings, I think the public service regulations even include fines.
Yes.
In there.
Yes.
As one of the sanctions.
Yes. I think I recall that, having sat on several of those administrative panels. This D, though, it's a little confusing to me. It says, include a requirement for the public officer directly or indirectly involved with the procurement process to declare an interest to include, I'm assuming they mean declare a conflict of interest. I don't know if this is an error of the Parliament or if this is an error of the submission they made. And then to include a conflict of interest, I'm not sure what they mean by that.
We're actually just trying to look back to find the submissions that were the submissions from the Integrity Commission. We're just going to try and look at that, but we have to find them first.
We're referring this particular recommendation to you to come back to us on. Okay, next one.
Last one on the general observation, Chairman, colleagues, is that page, well, whatever your page is, as it relates to actions of the Commission not void for want of form. The Integrity Commission Act has repealed Section 22 of the Contractor General Act, and no subsequent and equal provision has been provided. Given the complexity and variety of matters being treated with by the Commission, it is recommended that the Act be amended to include the provision that the proceedings of the Commission and or a director shall not be rendered void for want of or form.
On the general recommendations for, yeah, right. So we can move to the next set.
If let's make a decision on this, I don't see a difficulty. Yes, SG.
Sorry,
Yeah.
Chair. Just to go back to the fact that the recommendations before were referred to the Attorney General's chambers, we found the submissions. Yeah. And what's in the matrix is word for word. It's identical to what they submitted.
What the submission said, right?
But it's not very clear. The submissions aren't very clear. So there is no.
Oh, wait. Chairman, may I make a suggestion that we go through the general recommendations of the other parties before we move to the... Oh, okay.
No, you said I should defer my recommendation until I reach an issue relating to any of my stuff here. We are talking about... what second document? Speaking about something that was deleted, that was in the Contractor General's Act, and that happens to do my third amendment is the same thing. So maybe we could take that now as it relates to, they brought up the issue here. And I'm saying that, what I said, that this section, what this is basically. No, I'm talking about page 5 of my stuff here.
So just for good order, let us, we can transit to your recommendations.
Later on?
Yes.
All right.
No. We transit from these general recommendations
Yes.
because it relates directly to the Commission. Yes.
Yeah.
We will allow you to proceed.
All right.
Of course.
The first recommendation, as I said before, had to deal with the Auditor General, and it says a breach of Section 120, 121, 122 of the Constitution. And I believe it was on oversight when the Auditor General was included in the Act as a member of the Commission. Yeah. So I'm asking that the Section 1A appointing the Auditor General be deleted and replaced as Parliament deems appropriate, consistent with the object and purpose of the Act. I said that the removal of the Auditor General from the Commission does no harm to the integrity of the Commission, as the Auditor General may at any time conduct an audit of the Commission's affairs. Furthermore, the Act allows for the Commission to request reports and to enlist the cooperation from all organs of the state. So I'm saying here we delete Section 1, subsection A.
This has been a general consensus, and I would like to support Member Warmington here that we should remove the Auditor General from the list of persons who can be a commissioner.
Can you explain your rationale for it?
Well, apart from the fact that, you know, there's a general discussion as to who audits public bodies. And the Auditor General is usually the body to audit all public bodies, of which the Integrity Commission is one. So it would be almost inconsistent that because the Auditor General is a part of the Integrity Commissioners, you're going to ask some other body to audit the Integrity Commission. So to avoid that form, it's best not to make the Auditor General a member of the Commission.
Can I ask, in the past, have previous Auditors General sat on the Integrity Commission?
I think they've sat on Corruption Commission.
Oh, the anti-corruption,
Yes.
Because it's a new body.
Yes.
Okay.
But I think it was when we put this commission together, and by the way, it was not put under my chairmanship, even though I passed the law. But the report that came to Parliament, which we approved, had recommended a continuation of the Auditor General, but I thought it is a mistake on reflection.
Could I just ask the SG?
SG.
In terms of the recommendation from Member Warmington, if from your reading, if it is in fact unconstitutional based on the sections 120, 121, and 122 for the Auditor General to sit on the Integrity Commission.
Sorry, unconstitutional on what basis?
All right,
Or is it just a conflict issue?
So the issue is really about conflict of interest because she's the body that has to audit all government agencies. So it's not really a constitutional issue.
Page 4. It wasn't, I know it's a mistake on the part of those who put this together. But there's some stuff they put together in this act that should never have been there.
we need to proceed with this. SG, any guidance on this? CPC?
I just saying personally, I'll reserve. I'm not going to vote with the other members on this. I would want to consider it more before coming to a final opinion. Okay?
Okay.
I just want to remind you, if you don't mind, that a former leader of yours also made the recommendation of removing the Auditor General as a commissioner.
Chair, I want to join with Member Robinson. I think that we should have some discussion on it. I actually had a concern very early in my appointment as a shadow opposition spokesperson, and I was convinced that my concern was misplaced. I just would like it, we have not had any discussions around it, and since we are obviously not going to conclude today,
right.
I wouldn't mind if we had the opportunity to discuss it further. I must say, because it is my personality to do so, that I had some concerns about her sitting on the Integrity Commission as well. Sometimes you can't be influenced by the character of the person and the way that a person has conducted themselves.
No, you don't want
and that's actually what I'm saying, that you can't be influenced, that you should remove that from your contemplation and simply look at the position. And that's actually what I'm stating openly. And so if you would give us a little time to have some further deliberations on that, I would really appreciate it.
Okay, I'm minded to take into consideration the expressions of members that some more time could be given for further consideration on this particular recommendation. And I certainly would allow for it, both members Robinson and Motley. And we definitely have to make a determination on this by our next meeting, because I have to get these matters completed in good order to finish everything before certainly the end of this parliamentary session.
Yes, Chair.
In that case, Chairman, if the member or the members need more time for deliberation or to consider, then I'll ask that we defer all of my recommendation then until the next meeting, give them some more time to deliberate on it.
No, I wouldn't say that. I have other views on the others, but on this one, I would want more consideration on this specific one. I will share my views when the other ones come up.
All right.
Chairman.
Having not ruled that the member, his recommendations are not going to be considered today, I have not ruled on that.
Thank you.
So I think it's either that we finish the submissions that he has and then revert to the matrix as is.
Matrix. We're on the matrix.
So what you're trying to do is to infuse his recommendations within the frame of the matrix as we go along.
All right. I think that was agreed.
Okay. So we go to, I think the next one is page 17.
Chairman,
No.
I'm so sorry. I wanted to just make one point on the Auditor General issue.
Yes.
In section 120 of the Constitution, which does establish the office of the Auditor General, at subsection 3, the Auditor General, a person who has held the office of Auditor General, is prohibited from being appointed to any other public office. That's one of the things about once you serve as an Auditor General. Now, being a commissioner of the Integrity Commission is not a public office, but I am raising it because the considerations that would have informed that constitutional provision may very well be applicable to the Auditor General sitting on the Integrity Commission. So I ask the committee, when we are ready to deal with that, that we look at that. Yes.
I know, but I thought we were going to deal with all the general recommendations before we go to specific.
Well, no, I think we're dealing with the Integrity Commission as a subset. Yes. So we finish the Integrity Commission.
But that's that.
And then we take on the next one and we go through.
I thought you were going to go page.
It may make sense to do the general recommendations
For all.
first, for all of them.
Yes.
Yes.
I think that was it.
Yes, there is wisdom in that.
Chair.
I'm guiding team because we really want to be efficient in this.
We go. That's why we go through.
Chairman, if we take the general recommendations first across all groups, then we can take the recommendations from all groups for each clause.
That's right.
For each section. That is the most efficient way, Chairman.
Exactly.
I commend for your consideration.
Chair.
So move along to.
Chair,
So
sorry. Just one question. What was the decision in relation to the last recommendation where they're asking for the Integrity Commission is asking for Section 22 to be incorporated into that in their bill, the provision that was repealed from the Contractor General Act. Did we make a decision on that? On page 8, the very last recommendation of the Commission. Yes. Where they're asking for Section 22 of the Contractor General Act that was repealed to be inserted into the Integrity Commission Act. I don't have a decision on that recommendation.
Right. I thought you said we didn't have an objection. No, you're the one where. Right.
Are you saying
the repeal section?
There was
22.
a decision made on it?
For it not to be banned for want of form. You have an objection to it?
Where is the Contractor General's Act now in relation to
It has been
the fact
repealed,
that
Chair.
it's been subsumed into?
It has been repealed, but that provision, there's some provisions that were brought under the Integrity Commission Act.
Yes.
This particular provision was not incorporated
It was not
into
incorporated.
yes.
And so we have no difficulty with that.
Right. No. What we're saying is that, read it. We're saying this as it relates to actions of the Commission, not void for want of form. Not substance, So I'm saying
It's procedural.
yes, it's
But do we want to accept that we accept their procedural irregularities? Is that what you're saying? But that is what we would be agreeing to. That the procedural irregularities of the Integrity Commission are accepted. I don't know if I want to agree to that.
I don't know if they're going that far in terms of irregularity. You think so?
Chairman, through you, Section 22 is simple, and the wording is exactly that. Proceedings of a Contractor General shall not be rendered void for want of form.
Exactly.
But my difficulty with this, and I would require a little bit more time to examine it, is that form implicates due process. And if I am facing a potential corruption charge, then due process has to be a part of my rights in how I engage and how the system engages with me. And it's not protection of any potentially corrupt person. I want to make that clear. But there has to be a balancing of the rights of the person accused as well as the entity who is engaging the prosecution or the investigation of that person. So this one is not in my view,
The question.
an omission
void for
that you
water
just
form.
stick back in the Integrity Commission Act. It requires some consideration.
What about?
I mean, at the end of the day, you will take a policy decision. From my perspective, though, when I look at something like the 5th schedule, which is the summons to witness, what the Integrity Commission is saying is, even though they may not have correctly completed a summons to witness, or they didn't even send one, you could still then be facing consequences, even though they may not have submitted the summons to witness, or they may not have completed it correctly. And this is important because we have from permanent secretaries, regional directors, all sorts of persons who are getting these summonses. And there are consequences that flow. And I'm just picking just one thing out. And there are a number of procedures that are already stated in the Act. I'm repeating what Senator Golden Campbell is really saying, but just giving an example of where it could, I think, negatively impact someone who is under investigation. So I wouldn't even take it to another level, starting at the investigation level. And I'm not sure that I think you would have to think it through carefully to consider whether that risk to the person is worth giving the Integrity Commission the power to be able to continue their proceedings because there is a want of form. I think you have to weigh that risk.
Chairman, I would also be interested in knowing, and it might be within the SG's purview to find this information, whether at the time that the Contractor General's Act was repealed and the Integrity Commission Act passed in Parliament, the instructions in relation to what should constitute that draft bill were deliberate about, from a policy perspective, were deliberate about the omission of this clause. What informed that? Because I don't believe it was simply a mistake.
Can I deal? Well, in this case, I have an issue here of something that was.
No, but we need to just take a position on this, because I think in the context of the explanation and suggestion offered by the SG, I'm inclined to think that this recommendation shouldn't be accepted.
Chairman, both myself and Mrs. Seeley Brown can look at our respective files to see what information we can get from there.
So you come back to us on that?
Yes, we'd have to come back to you on it.
Member Warmington?
Yeah, I want Amendment 3 that I asked for. Whereas the Contractor General Act, the Parliament Integrity of Members Act, and the Corruption Prevention Act, together with this act, created a legislative scheme designed to identify, prevent, and where found, root out corruption. Part of these pieces of legislation were repealed and replaced in the Act, or left in place where the entire law was not repealed, as in the case of the Integrity of Members Act. In the case of the Contractor General Act, a number of the provisions were repealed and reinstated in the Act, except Section 20, which deals with the procedure after investigation. We provide as follows. 20 subsection 1. After conducting an investigation under this Act, a Contractor General shall in writing inform the principal officer of the public body concerned and the minister having responsibility, therefore, of the result of these investigations and make such recommendation as he considers necessary in respect of matter which was investigated. So on page 5. It says now, Section 2, subsection 20, subsection 2. There, this one, Chairman. It says if any report of a Contractor General reflects adversely upon any person the Contractor General shall, so far as practicable, inform that person of the substance of the report. There are similar provisions to be found in the Financial Administration and Audit Act governing investigation by the Auditor General. So what is saying here in the Contractor General Act, you inform the person of the adverse finding that you have, that they can respond. But this was left out inadvertently, I believe, from the Contractor General Act. So what I'm asking is for section 20, subsection 1, and section 20, subsection 2 of the Contractor General Act to be reinserted in the Integrity Commission Act. It's just due process. A person should know and be able to respond to these complaints of what it is. But that was taken out entirely. I'm asking to be placed back in it so that person can at least respond to these before it's published.
You could take a note of the recommendation from Member Warmington in that regard and to see how it fits into what the recommendation of the Integrity Commission is with regards to Section 22. So you are talking about Section 20.
Section 20.
Yes.
Subsection 1 and subsection 2.
Okay. So we'll get guidance from you further on that, SG.
Chairman, just to say that it could be treated a little differently because it's more a matter of the natural justice and regularity of process, why the submission from the member makes sense and could be considered by the committee and accepted.
Yeah. So that's an added point for the SG to consider when she comes back to us.
At the end of the day, whatever the SG comes back to us on as to the rationale that informed taking Section 20 out of the current law. No, I'm talking about 20 that Minister Warmington just spoke to. My concern about a Section 20, and I also agree that a person who is being investigated and against who there is an adverse report ought to have an opportunity to respond to those adverse findings. However, I am of the view, and I could be wrong, that currently in the course of the Integrity Commission's investigations, they do send requisitions, they do ask questions, and the person to whom they ask a question is compelled to respond, and there's written responses given, so that there is an understanding that an investigation is happening. Now, they will do that to witnesses as well as perhaps to the subject of the investigation. I am concerned about 21 as it is written in the old Contractor General Act, because in a situation of a corrupt act in central government, the principal officer or the minister responsible may not be the persons that the Integrity Commission wants to notify, right? And I want to be careful. I don't want my ministers and my PSs to get concerned about me perhaps accusing anybody. But if you have a corrupt PS or a corrupt minister, and the Integrity Commission is conducting an investigation, then all you're doing by disclosing to them is to give them warning. This, to me, is corrected in the current act by the requirement that the Integrity Commission has to table its report. Because once it's tabled and published in the Parliament, it's available for anybody to read and review. And Parliament can do whatever it wishes in terms of the various committees that would be reviewing such a report. So I'm interested in hearing the rationale, but already I can see it's not as straight as just, you know, the person needs to know. There are some considerations because of the nature of the offenses that this bill would cover.
Chairman, what I'm saying here, yes, the person being investigated is aware. What is saying here, if you have adverse findings, before you send to Parliament or publish it, the person should have a right, you know, as it was before, to know of what you're saying before it. Then they can respond. Because there are other cases where the Auditor General herself also, that department, write stuff, and in the long run, they were not correct. Same within the Integrity Commission. So you give the person a chance when you complete and you claim that you find this, you notify a person. I'm not talking about doing an investigation to alert them. But at the end, you give the person a chance to respond. And in that case, the person's response should also be included in what we're tabling in Parliament.
Chair, I definitely agree with that part that Member Warmington just mentioned in relation to persons being given the opportunity to respond and those responses being or forming part of the report. I don't think the Integrity Commission should be providing a report with information omitted. I think that, for me, really requires some kind of thought or further discussion. But there are aspects of this that I will agree with.
Sure.
We're taking note of that contribution from.
I just wanted to support what the member was saying, because you'll recall that when we read the minutes before, Senator Bunting had raised a concern that there were certain responses which he gave which were not included in the report. They were ignored totally.
Yes,
and I think in fairness, the recommendation that the person's response be also included is good.
Okay, so I think you have fulsome guidance there, SG, in helping.
Chair, really what I'm going to be doing is looking back at our file to see if we can find the rationale for the changes that were made, what was not included. And I was speaking with my colleague, Mrs. Celia Brown. She will also do the same with the file at the Office of the Parliamentary Counsel.
I think that within our remit is to make recommendations that either changes the nature of what is suggested here, you know, to strengthen the legislations that we are reviewing. So it is quite in order for us to look at what can be added and indeed what can be subtracted from the provisions that are there. Okay.
So what we'd do, if my recommendation would be go page by page to deal with all the general recommendations. If that is, so when we go first to the Jamaicans for Justice, the recommendation, it is being proposed to embed the Integrity Commission as a body of the Constitution, similar to the Director of Public Prosecution and the Auditor General, rather than remaining as a body of statute. No, Chairman. Then, first of all, what are you going to embed? I'm not too sure what would be embed, so I don't know if we just disagree. If you don't mind, we go to the next one from Lands. Some members of our movements do not trust politicians to be responsible for the appointment of a supposedly non-political body. Some persons believe that there should be greater involvement of the Auditor General and the general public in the process for appointing members of the Integrity Commission. Next one, so no. Next one is Norman Manley Law School. It is recommended that the act should include a table of contents.
Oh, you missed Best FM.
Huh?
Sorry, I'm so sorry, Chair. Marlene Aldred, I'm so sorry. I understand that you're moving with due dispatch, but I have no notes. I'm not sure what was the decision JFJ, no. And for Lance, no. Okay. And for Best FM?
Oh.
Okay. And I do apologize for interrupting your proceedings.
All right, sorry. It's another Best the Morning Connection. It has been proposed to develop a social credit system with the demerit points being one way of establishing administrative actions that could police that sector with greater effectiveness. This is an area in which administrative action could be taken, and it has been suggested that breaches could be punishable by the imposition of daily fines for the period. What is this all about? Okay, the Norman Manley Law School. Yes, go ahead. It is recommended that the Act should include a table of contents page. I would say yes. Yes. And the rationale being that it make it more easily accessible.
You know, that's a law revision decision. Yes, but the bills usually have
a table of contents, yes.
Not a table of contents.
You mean, I think they made the objects and reasons, but it's not included in your laws, which is, I find kind of strange too. When you
decision was taken
to add,
some time ago, but it has to come back.
Yeah, because in some jurisdictions
no, but
it is
makes
incorporated.
Sense. It makes sense
should
anyway.
be.
All right, the private sector organization of the Act does not give the Commission a lot of power to enforce certain requirements, nor is there a penalty for every omission or delay on the part of a person who has an obligation under the Act. The Act should include penalties for failure to fulfill obligations, or any delay, and consideration should be given to whether the Commission or directors should have the power to take a certain enforcement action. But they do now. They do. Am I not right, colleagues? They give you time, and when you don't respond, they report. Yes. So I think this is an overreach.
Sorry, Chair, but the note for the Norman Manley Law School, is it that you agree, but you see the point is the table of contents will be in the law when it enters the laws of Jamaica, the revised pages. You don't always have, I think what they're referring to is if you go on the Parliament's website, when you download the Act, there's no table of content with it. But when it's printed and included in the revised laws of Jamaica, it would have the content, a contents page, because it's a part of the requirement of every law.
Okay.
But may I just say that it makes good sense to have it included even at the bill stage.
Absolutely.
The documents usually come in two parts, and I believe if it does not require any amendment to the Law Revision Act at this time, and even if it does, because it's a positive action, just given the little area of responsibility that I have for those matters, I would say going forward, yes, it should be included until...
So the note here is agreed?
Did we deal,
accepted.
Did we deal with Member Warmington matter? We did? Okay. Right. Okay, so
we accept the recommendation of the Norman Manley.
Right. The next one, again, is from Jamaicans for Justice. Right. The following recommendations that are to be made to the Protected Disclosure Act. Here again, Chairman, we leave this for the Protected Disclosure, right? And then across we look to protect. Yes. No, lands.
The recommendation is for a reference in the Integrity Commission Act to the Protected Disclosure Act when you read the substance of it.
Yes, but I think right. The next one is lands, Chairman.
A recommendation that the Integrity Commission Act be amended is a proper recommendation for here, whether you accept it or not. A recommendation for the Protected Disclosure Act to be amended is another matter. So it says it is proposed to amend the Integrity Commission Act subject to amendments to the Protected Disclosure Act, ensuring necessary inclusion and reference. Rationale, inclusion or reference to the Protected Disclosure Act must be made in the Integrity Commission Act, similar to what exists. Well,
may I say, Chairman, we have already, and I hope it will continue, make the Integrity Commission a competent authority for the protected disclosure.
dismiss it without considering.
No, but you don't need to, since they're already one of the members.
It's not the same thing. At least let's consider the thing and come to a decision. But just don't dismiss it like that.
So you would sort of give it statutory status.
I'm not saying that it should be. I'm just saying, let's not just flip it off.
We ask the OPC for guidance, okay? The question is whether...
Let me tell you, the problem I have is that it appears that almost every act wants every provision to be in that act without recognizing that the laws of Jamaica generally are available and they apply where there is a requirement. So if you have a provision in respect to the protection of disclosure, and a disclosure is made in the context of the Integrity Commission, there is nothing that says that the Protected Disclosure Act doesn't apply.
So
It reflects the lack of understanding in some quarters about how to use the laws of Jamaica.
but you're suggesting that we... That's my view. Okay. All right. Lands, the next one is...
Can I just make another point, Chair, with respect to anonymous reporting? Look, if you look at Section 37.5 of the Integrity Act currently.
31?
37.5, it says, no person shall be obligated or permitted to disclose the name or address of a person who makes a complaint under subsection 1 or state any matter which may lead to the identity of such person being known, and there's an offense.
Which section are you reading?
Section 37.5.
37?
Yes,
You said
37.5. So you already have that protection in the Integrity Commission Act. So I'm not clear what is intended here.
I think we can make that notation. The provision here.
Chairman, my simple point was that groups come here and they get a lot of publicity, and when you come to closely examine their submissions, they fall short of substance.
Yes.
So, in considering them, we need to point out the reason for or rejecting or accepting the submissions.
Yeah.
Because a lot of publicity is given to a lot of misinformed submissions and inaccurate submissions in law, or incomplete submissions, and they become inaccurate by virtue of the incompletion.
So I'm not disagreeing with you at all. The extent to which we go, however to do it, you know, is a function of what's before us and the time we have to deal with all of these matters today. I think we had a solution here in that provision is already somewhere else.
That's the point, Chairman, to say that it needs to be put out that this submission fails to take into account a clear provision that achieves the same goal under the law, in the same law. In the same law.
Lands, we would appreciate the inclusion of a clause to serve the same purpose as Section 17 of the Protective Disclosure Act, which states, where an employee suffers occupational detriment at or about the same time that he makes a protected disclosure, the occupational detriment shall be presumed to be a consequence of the protective disclosure, unless the employer shows that the act that constitutes the occupational detriment is otherwise justified. For the purpose of the Integrity Commission, the clause would not need to be specific to occupational detriment. It could refer to an instance where a person is met with any harmful action around the same time that such person makes a claim, to allow for it to be legally presumed to be a consequence of making or seeking to make a claim.
It's there, Chair. The same
Same
clause.
point.
Yes, section 30.
Okay, Chairman.
7.
We can move on.
It says an
No,
offense.
excuse me, Chair. Marlene Aldred. I'm sorry to go back to the JFJ recommendation, but in their rationale, they spoke about what exists in Turks and Caicos. So we have just actually been going through the Turks and Caicos Act, and I see the problem. So in the corruption ordinance in Turks and Caicos, they actually have a part that's titled Whistleblower Protection, and when you look through that part, it looks eerily similar to our Protected Disclosures Act. So the point is, we actually have a separate regime, a separate act. They actually included this as a part of their Integrity Commission Act. So it's just a different scheme. So we don't have it as part of our, although Mrs. Celia Brown will be pointing you to some discrete provisions that do address some of the issues, but we actually have what they have in their part as an act. So I think that is perhaps why you will see a recurring theme of presenters sending in submissions saying, just as what you have in the Protected Disclosures Act, you should repeat it in the Integrity Commission Act. And they will be looking to Turks and Caicos, not understanding that there it was done differently. It was incorporated as one law, whereas we have two separate laws. But our Protected Disclosures Act goes wider than the one in Turks and Caicos, because in Turks and Caicos, it starts out by talking about a public official. And it's only limited to public officials. Ours is wider, much wider. And if we were going to put it in our Integrity Commission Act, it would be restricted to public officials, because remember, the whole point of this Integrity Commission Act is it governs public officials.
So Chairman, added to that point, so we know why a comparison is being made with the Turks and Caicos, because the executive director of the Integrity Commission did say that he had spent some time there and had seen and experienced the jurisdiction. But I think the point made by the Solicitor General underscores the earlier point of how the failure to take into account our laws in general result in incomplete and hence inaccurate submissions, giving the impression that certain things are not in the jurisdiction, and the absence of those certain things which they erroneously claim are not in the jurisdiction hamper the work of the Commission.
Chairman is from JFJ, page 2 or 3, depending on the body you're using. JFJ calls on the government of Jamaica to make the following urgent recommendations and actions relating to the Access to Information Act. Increase public awareness of the legal right to access government information and for increased public use of the ATI's Act's procedure for requesting information. Creation of clearer guidelines which address the cumbersome, inefficient, and bureaucratic process to request information that deters public utilization. 3, need for a legislative oversight body. The unit set up to oversee the operations of the Access to Information Act must be transformed into a statutory body to develop and enforce guidelines.
I just want to take note of how everybody wants to be an oversight body and they want to be accountable to no one.
And I mean, the rest of it again is not really relevant. This is about recommendations about the ATI. So Chairman, I don't want to read the rest of it. It is all about the Access to Information Act. Is that okay, Chairman? So that.
So back to the point that Member Malahoo is championing, that the reason behind it be given, as we are not going to be accepting this. So what's the rationale for not accepting it?
It's not within the remit of this committee.
The same, no, we just want to make sure that that report reflects. It is the same principle that this is covered, absolutely. Yes. I just don't want it to be felt that, as the member inferred, that we're just rushing through and not paying full attention to the
May I just say,
considerations.
notwithstanding the valid concerns raised, there is in fact a problem for people to access information in government in certain quarters. But I'd just like to say to those listening that if the information is available on the websites, because I know almost all MDAs are now utilizing websites to put out information, and we have come a long way in implementing openness and access to information since the Act was passed. Really, I have seen requests for information that is already in the public domain.
Yes.
Chairman, okay, if we can move on then. From the Ministry of Finance and the Public Service, FID Department, creation of a new offense for misleading, obstructing, or non-compliance with requests from the Director of Investigation, contrary to Section 51. Creation of a section that... Page 6 or 8.
Page 6.
Ministry of Finance and the Public Service. We're still dealing with general observations.
They don't have any.
Bottom of page 6 or page 8. The very
Must be
bottom.
Page 8. No?
Yes. It's just that I have two different things. Yeah, no, we're at Ministry of Finance and the Public Service. And the second part is creation of a section that provide the action of the Commission not to be void for want of form.
I don't see. Sorry, help me with this one, because I don't have anything on the Ministry of Finance.
It's at the very bottom of your page 6 or page 8.
Which says creation of a new office for
That's right.
misleading. Okay, good. All right.
I don't know. What's the colleagues?
Yeah, the creation of a new office for misleading,
Offense.
obstructing. Oh,
But I'm sure that is there already. I'm sure that is there already.
Chairman, I wish to make a general observation. I note an emerging trend where authorities want more and more offenses to be created. It is not necessarily the wisest approach to take. Because when you create offenses and you are not prosecuting, or you're slow in prosecution, it really doesn't help the case. And I think given the wide remit and budget of the Integrity Commission, greater emphasis need to be placed on the role of educating people about the importance of doing the things that would lead to a less corrupt society. But the over-concentration on the punitive side to the detriment of the matters that can foster a new culture is of concern to me.
But what is it that they're asking here for? They're asking for
obstruction.
Yes, they're asking for an offense for misleading,
so if it is not there,
or non-compliance with the requests of the director, that is not included already.
We have run into a little problem. Once upon a time, matters that would apply across the board were placed in the Criminal Justice Administration Act or one of the other acts that deal right across. I think over time, different pieces of legislation have included specific provisions, and this one is, this offense that is being asked for is one that you find in almost every act.
That's what I figured.
Right? So the question is, if it exists elsewhere and it is not here, whether the ask is a reasonable ask and it should be granted.
Okay, so what's the view of the committee on this one? Yes? Yes?
What I remember us when we drafted this bill is that we included some of the provisions of the Commissions of Inquiry Act. And if you look at section 48.3 of the Integrity Commission Act.
48 what?
48.3. It says for the purposes of conducting an investigation, he has the same powers as a commissioner. And if you look at the amendments to that act, those offenses are there, so it will apply. So because 11C is listed as applying mutatis mutandis in relation to an investigation, and they've all created the offenses of assault, obstructing, hindering, or those sort of offenses.
48.3. So it has the powers already.
Yes, so I'm going to have to check to see if I'll look to see if this particular offense is.
It's already covered.
Yes, but I think it is from my close review of the amendment
Chair.
that was done to the Commissions of Inquiry Act.
Maybe is ignorance around the application of the provision.
Yeah.
So we'll get guidance on that one.
You can check on it, and then after lunch we can hear it.
Because we're
And by the way,
mutatis
we did plan lunch for 1 o'clock, and I think there's provision
now 1 o'clock.
downstairs. So
we finish the general observations.
So we finish the general observations, and we'll come back to deal with the more specific recommendations. Okay. This meeting is suspended for luncheon break. 1 hour. Half an hour, yes. Half an hour, we come back at 1:30.
Join us this week for Tourism One-on-One, when we examine the Ministry of Tourism's innovative Tourism Workers Pension Scheme and efforts to enroll tourism workers.